ولا رئيس الجمهورية دكتور رياك. نرجع المايك لمثيان والمزيد من التعليق.
Yeah, that is from Martin Justin Coste, highlighting you in classic Arabic regarding the proceedings. Still waiting for the judges to arrive in less than in some minutes. They will be arriving into the courtroom, leading to the commencement of the hearing. Again, is hearing in the case of Pout Kang, the prime accused, and 7 others. The charges include terrorism, murder, conspiracy, and crime against humanity, which the country's constitution doesn't allow if regionally or internationally. In a body within the government, constitution stands taller than anyone, despite of the position someone holds in the government. So the law stands tall than anybody, and this is a commencement and of the venturing into the constitution, the effective justice system, which is being indicated in the country's law. Now the court is still quiet, waiting for the arrival of the presiding judges, being led by James Alala. Prosecution team, defense team already set with all the documents filling up the tables. Hey, you wonder what could be the issue, but this is all about legal proceedings. Both parties have got their say, their objections, and as a prosecution team, last time objected the participation of the 2 advocates, being their license had expired, asking the court to expel the 2 advocates to allow effective, hearing, effective continuation of the proceedings. If not, this violates the Advocates Act 2013, indicating that any person wants to participate in court should be legally registered, having the license showing the participation. If not, then the advocates without license are not allowed to be participating. So it depends on the court, the judges, to see into this issue as we wait for them to arrive shortly to let the proceedings commence. Media houses are in, everybody's in, court is full, all the seats are full. Everyone is waiting quietly for the commencement of the proceedings. This is all about it, and we are ready to give you live updates now and then. And then it is you, the public, the viewers, to draw your attention, to draw your conclusion about these proceedings. Now let me give back the microphone to Leila Osman to give you more on this.
Thank you very much, my thank Joseph, my colleague at the Freedom Hall. As witness in the hall, expectation seems to be high amongst those watching the proceedings at the court here at Freedom Hall. Just to give you a brief summary before I go back to my colleague in the studio, that is Gori Anthony. Just a brief summary of those of the 8 accused, starting with the proceeding of the court order. That is beginning with the suspended Minister of Petroleum, Pout Kang, who is the first accused, followed by Mampal, aged 27, a businessman, Gatwi Shilam, a member of parliament, aged 66 years, Lieutenant General Gabriel Doplam, deputy chief of the SSPDF, aged 53, followed by the 5th accused, that is Dr. Riek Machar, the suspended first vice president of the Republic of South Sudan, 73 years old, and followed by the 6th, that is Brigadier Camilo Gatmai Kel, head of administration, National and Finance Transitional Security Committee, that is age 47, and then followed by the 7th accused, that is Mading Riek, signal personnel, radio operator, aged 45 years, and then followed by lastly, that is the 8th accused, that is Dominic Gatkok Riek, a generator operator, in the office of the suspended first vice president, aged 27 years old. We'll continue briefing you. Please stay tuned to SSPC, as we'll be bringing more live coverage of the event happening live at the Freedom Hall, and also coordinating with our colleague Gore Anthony back in the studio. I hand over back to Gore Anthony in the studio.
Reporters, we have Leila Osman, Matiang Joseph, and we have Martin Justin Kose, and also Oliver Mori. These are some of the reporters that are assigned on the ground to be able to cover for us this special court proceedings from Freedom Hall, where we are just expecting the arrival of the presiding over judge. We are having 3 judges that are appointed by the authority, the highest authority of the country, to ensure that they handle this case. And of course, the jurist or the panel of jurists, including Justice Dr. James Alala Deng, who is also the presiding over judge who takes control of these proceedings, supported or assisted by Justice Stephen Simon, as well as Justice Isaac Pur Majak, who are appointed by the country's Chief Justice to handle this case at hand. And of course, viewers, as you've just seen or you've watched at Freedom Hall, the hall today is full. People from all walks of life were allowed to be able to attend this session. We have also national and international observers who happen to turn up to be part of these court proceedings at Freedom Hall. And we also have scholars, those who are actually taking out law studies, and those who are also doing the studies to be able to get knowledge and skills on how the court procession is taking place, so on and so forth, to help them, support them in their field. And also we have friends and families who happen to also got at Freedom Hall courtroom today to be able to attend this court procession. And of course, viewers, as you remember from the beginning, we said the court, according to the presiding over judge, Dr. James Alala, he opened up the court to the public. And that's why you've seen from the day one to today, it is different, because the government wanted elements of credibility, impartiality, fairness, and that's why it is open to public. So anything at the public domain. And don't forget also, SSBC, we are all live on our YouTube account, we are live on our Facebook account, and we are live on all our TV stations that shows the commitment of the government. Anything that is done live, normally there is no editing. We do it live on the ground. That shows each and every step that is happening at Freedom Hall, all the people, because this case is being observed, being monitored by the region and international community, and people are monitoring or following up this case closely to ensure that the trial or the case at hand is being actually taken up to the last stage to prove whether the suspect or the accused are guilty or innocent. This will be determined as the court procession or the court proceeding continues for the case of Nasir that culminated due to the killing of more than 250 members of the SSPDF plus Major General David Majur, and also one pilot of the UN who happened to be sent to evacuate Major General, and in the process he also got killed. So these are some of the issues that is taking place. But as we know that currently we are dwelling in what is called judiciary on trial process, which determined if the established special court is proven to be competent to handle or try the case at hand on the charges leveled, on all the charges put against the accused. This stage is determined by the 3 presiding judges, as we said in the beginning, and then the defense team and the prosecution team, as well as those who stand on the ground to ensure that the court process or the court proceeding went on successfully. And as of today, viewers, we are expecting, as we are still waiting for the arrival of the presiding over judges, we are actually expecting the panel of jurists headed by Dr. James Alala, and also supported by Justice Stephen Simon and Justice Isaac Pur Majak, to pass a verdict. They are going to pass judgment. This judgment is going to be based on the subject matter after which is to read out after when they pass the verdict, actually judging the two sides from the prosecution team and the defense team, then they will pass verdict to ensure now the court process continues from there. And this shows that from now onward, then we can be able to hear the number of the, the charges that were leveled against the accused. And of course, from the beginning, viewers, if we could remember, some of these charges that were leveled against the 8 accused headed by actually the lead accused, which is Kang. If you could remember that from the beginning, viewers, the Minister of Justice and Constitutional Affairs, or Dr. Kang, actually read out some of the charges that were leveled against the accused, and this including treason, act of terrorism, then we have murder, we have conspiracy, common intention, terrorism, financing, and then we have destruction of public property and military assets, crime against humanity, and then systematic attack on civilians and ethnic-based persecution. These are some of the case or some of the charges that were leveled against the accused, who are actually at the courtroom as we speak. And as you could see, the attendance of the courtroom, you could see up to the brim. Freedom Hall today is just very full. People from all walks of life converge there to be able to attend these court proceedings. This shows the importance of this case at hand. As you could see, the accused also seated from the first accused, who is Kang, down to the remaining other members who happen to be part and partial or in connection with the Nasir incident. And these are the defense team. You could see them, defense team headed by Dr. Gary. And then we also have the accused team headed by Justice Chwil Adija. And we have also the presiding over, or the panel of judges headed by Dr. James Alala. You could see today it's a different day, and the environment is peaceful, the place is harmonious, and you could see the move as being put by our cameras and our reporters down. Everyone, people from all walks of life, stand up to attend this court. And of course, from the beginning, people were saying the court is not going to be open, but you could see it's open to the public, and we're just awaiting in a few seconds or few minutes from now to see the arrival of the presiding over judge, 3 panel of judges headed by Dr. James Alala Deng, who will be presiding over this event. And as we said from the beginning, viewers, that today is a day that will now cut the remaining 3 days, day 1, day 2, day 3. Now we will now move to a next session where the verdict will be passed, the judgment will be passed, to ensure that the court process now continue or moved on. Then from there we could be able to hear some of the charges that were leveled against the accused, the 8 accused. As top of them is Kang, who is the prime suspect according to the government filed case. And you could see, people, that this event is live on our YouTube. Those who could not access us on television, you could log into SSBC Official, or also log into SSBC Official Facebook account. You will be able to watch us live from the, yes, you can be able to watch us live from from Freedom Hall as we relate to you this live event. Let's also get some few remarks from or views from our reporters. We have Leila Osman on the ground, we have Matthew Joseph, we have Martin Justin Kose. These are some of the SSBC reporters who are actually in the courtroom as we speak, and they are monitoring closely from the event there. In the next few minutes, we'll be expecting the arrival of the presiding over judges. Let's now get back to Freedom Hall and hear some few views or few remarks from our colleagues down at the courtroom.
Selector Isaka, Phantom, Best Production.
Thank you, Gore Anthony. Welcome back to Freedom Hall. I am Mathiang Joseph. Still waiting for the judges to arrive in the next 20 minutes. We shall, the proceedings will commence as the audience waiting quietly, and all seats are full. Attendance is huge. Both parties, the prosecution and defense teams, arrived. The accused already in the room, and everybody is quiet. Nobody is allowed to talk in court. And the adjournment last week, when the prosecution team objected the participation of two advocates from the defense team, and that they should not be allowed to participate as their license had expired, and that violates the Advocates Act 2013. This is what is happening in the court. Expectations are high from the audience. This is the beginning of the country's judicial system effectively since independence. This kind of high-profile case against SPLM IO senior members, including Pout, Kang and 7 others, charged with crimes against humanity, destruction of public property, conspiracy, treason, and terrorism. This is all about the incident in Nasser when more than 250 SSPDF soldiers were murdered alongside their commanding officer, Major Dak. This really sparked off the arrest of all the SPLM IO senior members linked to the incident. And this brings us to this high-profile court hearing today at Freedom Hall in Juba. This is all about the constitution of the country. Constitution indicates nobody is taller than it. This is all about the national constitution. Regionally, internationally, the law stands taller than anybody, whether in government or in private. This is all about it. Let me give the microphone to Leila Osman to give you more updates about this court hearing.
Thank you, Martin Joseph, my colleague Peter Mori, and Martin Kose, live reporting from at Freedom Hall here. Just a brief reminder for those who could have just joined us today during the 4th day of the court proceeding at the Freedom Hall here in Juba. I'll give you a brief summary of the judges presiding over the case and the list of the defense, both and the prosecution teams. In the trial of both Kang, the suspended Minister of Petroleum, and 7 accused others, including suspended First Vice President Dr. Riek Machar. The special court panel is composed of 3 judges. That is James Alaladeng, who is presiding over the proceedings, along with Judge Stephen Simon and Judge Isaac Poor. The public prosecution team comprises of 13 counsel generals of the Ministry of Justice. That is Deng Achwil Adija, who is the lead judge, and Dr. Sabir Wani Lado, Sarafino Simon Mizan, and Philbato Magwot Mareng. Others also include Advocate Ajo Noel Ohisa, followed by Advocate Gabriel Mading Apash, Judge Advocate Deng Mabiordeng, Philip Anyang Ngang, Advocate Ajak Mayol Bior, Advocate Mata Jobet Jeremiah, James Bone Michael, Advocate Peter Garang, and Counsel Botres Yai Adu. Those are the 13 counsel on the prosecution side. When we go to the defense side team for the 8th accused, that is Pout Kang, in terms of order, and the suspended Minister of Petroleum. The presiding defense team that are led by Dr. Giri Raymond Lege, Anthony Kour Lual, Anthony Anis Tombe Agostino, then Advocate John Deng John, Advocate Wanyang Kir Wanyang, and Advocate Regina Akiria Deng. The case also involves investigators that is supporting the prosecution, including Brigadier General John Duck and Major General Basile Thomas Wani, a legal captain from the Internal Security Service, that is Captain Richard, who is one of the complainants. I'll hand over to my colleague, that is Martin Kose, for more briefing on what is happening at the courtroom. The court seems packed and full compared to day 1 and 3, and the anticipation is high among us, those attending the proceeding. So we wait to hear more as the proceeding, comes into light, as we await for the arrival of the presiding judge, that is James Alala Deng. Keep tuned to SSBC for more details of the live coverage proceeding at the Freedom Hall here in Juba. Martin, please, maybe you'll give a brief summary for the Arabic viewers, listeners.
أسلم كثير زميلة ليلى عثمان. نعم سيداتي وسادتي في كل مكان، ما زلنا بقاعة الحرية في جوبا في انتظار وصول قضاة المحكمة الخاصة اللي بتمثل فيه 3 قضاة وعلى راسهم جامع الزلالة. نعم هذه المحكمة بدأت في الأسبوع الماضي وما زلنا في مواصلتها لهذه القضايا، والمحكمة ما جات ساكت نعم. والمحكمة طبعا زي ما قلت بننتظر انه لسه ما زلنا في عملية بتاعت اعتراضات وقبول وعدم قبول وعدم قانونية وكل، يعني نحس في انتظار انه هل هذه المحكمة مؤهلة ولا ما مؤهلة. لسه منتظرين نتيجة الامر ونحن في انتظار الكلام ده عشان نقدر نعرف انه كيف القضية بقدر بيصير. القاء مليان بقانونيين، مليانين بمثقفين ومتابعين للشأن القانوني في البلاد، وايضا مناصري للمتهمين. والجرائم الموجهة ضد المتهمين زي ما انا كنت بتكلم انه بيتعلق بالارهاب وتمويل الاعمال الارهابيه، وعندك تدمير الممتلكات العامه والعسكريه، التآمر ضد الدوله، يعني كلها جرائم موجهه ضد الدوله. وهذه الجرائم حسب القانون الدستور ايضا بيحكم عليه بغض النظر عن من انت. وزي ما ذكرت انه ايضا هذه المحكمه تمثل فاصله او نقطه في تاريخ المحاكم في جنوب السودان، فريده من نوعها وايضا حساسه، وبيحتاج لعقلية كبيرة جدا انه الناس تتعامل بها. But young Joseph, we have also, because we are still waiting for the judges to come, and we don't know, maybe a few minutes and they will be arriving. And of course, the last session has been adjourned, just about the issue of proceedings, and the prosecution have raised a case that 2 advocates are not supposed to be in the, yes, and based on the and if you see the Advocate Act 2013, it shows that really if you don't have license you're supposed not to be. You cannot practice. Although there is an order been issued by the Chief Justice in 2016, particularly in 2nd November. That court, that order is saying that if you don't have license, also you're supposed not to be in the court. And if you're a trainee is allowed, but if they come with a letter from the representative, yes, that is it. So Mathiang, you have, if you more, you can add.
Okay. Thank you, Justin Martin. Yeah, this is still, early for us to give in convictions or analysis on these proceedings, but now the courtroom is the atmosphere is cordial as accused Pout Kang and his 7 accused are allowed to interact with their supporters in the courtroom. Not even supporters, but the defense team. They are being seen, exchanging greetings, with a smile, on their faces. And the courtroom is friendly. Everyone is waiting. Expectations are high because this marks the beginning of the country's justice system since independence. This kind of high-profile, trial, and this is trial against Pout Kang for having, allegedly committed crime against humanity and destruction of public property, conspiracy, conniving with the criminals trying to destabilize the country. And the law steps in saying, no, this is all about, the constitution. Nobody's taller. Nobody's immune to the country's law. And nobody should be committing crimes or trying to destabilize the country. This is all about, the constitution. Already the judge is expected to arrive in some few minutes to come. Prosecution and defense team already waiting. And during adjournment of the proceedings to Monday today, the reason was to allow the judges, the court, to examine the long written documents studying from both parties before the real rulings commence. This is all about the court, and we have more to give you now and then. This is Matiang Joseph giving you the microphone to my colleague Leila Osman. If not, we have to go back to the studio, allowing Gori Anthony to give you more analysis on the matter.
Best production.
Watani, Juno Beledi, Anabihibu Makugel Batai, Beledi, Juno Watani, Anabihibu Makugel Batai, Watani, Juno Beledi, Anabihibu Makugel Batai, Beledi, Juno Watani, Anabihibu Makugel Batai. Kelina dala modola tanina mama doula al dunya kulu muktene kelina dala modola tanina yakwane doula al alam kulu muktene rabuna wadi kulu fogo kera al bisibo belet ganiane rabuna wadi kulu fogo kera mama kera al bisibo belet ganiane kanina kobru doula de magel bakwe doula de bikundo lalgowi kanina kobru doula de magel bakwes doula de bikundo lalgowi juno beledi anabihibu maklugel batai beledi juno watani anabihibu maklugel batai watani juno beledi anabihibu maklugel batai beledi juno watani anabihibu maklugel batai.
Kanita gihibu bele take ita bishtaka fogo bekulu gelba obe amana
kanina karabu dola jamil de makerato wama bikun kwez kanina karabu bele tiafa de makerato wama bikun kwez rabuna behasi bonena yakwani kanina mafisu belede rabuna behasi bonena mama kanina mainu belede muslia tabelede kanina kulu sawa sawa na kutubala kanina mama sandola de birabakwe juno beledi anabihibu maklugel batai beledi juno watani anabihibu maklugel batai watani juno beledi anabihibu maklugel batai beledi juno watani anabihibu maklugel batai mata dola de ketirle nina kankesi musawa sawa vitimu kerata bele de kifaya lenina kankesi musawa sawa vitimu mata geni zulu makwana dola de tanina sawa mata zulu makwana dola de tanina sawa.
Yes, viewers of SSBC, thank you so much. You're still joining us live from Juba, both in our studios and also at Freedom Hall, where the court proceedings is taking place for suspects who are actually in connection with the Nasir incident. And of course, as the saying goes, that a suspect is innocent until is proven guilty by the court of law. And this is what is happening as you've been watching us live from both our studio and then at Freedom Hall courtroom, where we just are waiting the arrival of the three presiding over jurists or panel of judges headed by Justice Dr. James Alala, and also supported by a number of two judges, that is including Justice Stephen Simon and also Justice Isaac Pur Majak, who were actually appointed by the country's Chief Justice to handle this case at hand. As from the beginning, viewers, we said, today we are awaiting the verdict, or we are awaiting the passing of judgment by the presiding over judge and the two other justices who are going to convene shortly. In a few minutes from now, they will convene on Freedom Hall, and they will pass judgment on some of the objections from both the from the prosecution team and also from the defense team. They are going to pass a verdict, and this verdict will actually give us a new move where we will be seeing the next move, that is to ensure that the court process continues, and then we will be able to hear some of these charges that are leveled against the accused, the 8 accused headed by one which is the leading accused or the top prime accused, that is Kang, who is on top of the list, and then headed by the rest, or including the rest of the accused. Back in the courtroom, viewers, we are having 4 members or counsel generals in the Ministry of Justice and Constitutional Affairs who are actually in the prosecution team. We have also 7 advocates who are members of the prosecution team, and also we are headed by Advocate Deng Achwil Adija, who is heading the prosecution team. And we also have 2 investigators who are members of the prosecution panel and 1 complainer also as part of this case. On the other hand, viewers, we have 6 advocates from the defense team representing Dr. Riek Machar and 7 other accused, or representing Kang and 7 other accused on the ongoing court proceedings. And it is led by Dr. Gary Raimondo Lege. And we have 8 accused, including Kang, the first suspect. Suspect number 2 is Mampal, then Garwich Lamboth. And when we have Lieutenant General Gabriel Doplam, we have Dr. Riek Machar, number 5 in the list, and we have Brigadier General Camilo Gatmai, then we have Mading Riek, and we have Dominic Gatkoth. These are some of the suspects who are actually in the courtroom, and they will be actually standing their ground with the defense team to be able to respond to some of the cases that are leveled, or some of the charges that are leveled against them. But this will happen only if today the presiding judges will be able to pass verdict on some of the issues or some of the matters that were put across by the prosecution team and the defense team. There are some objections to the court's jurisdictions, and then also legal process, so on and so forth. So today, as we are waiting for the presiding over judges, they are arriving in a short while, they will be able to pass a verdict that will ensure the commencement of the case from day 1 up to today, of course, which is the 4th day. We have not yet had some of these charges being read out. But by today, if the presiding over judges pass verdict on the matter at hand or the case at hand, then we could be able to hear these charges being read out by the prosecution team who filed the case against the accused, Kang, and the 7 other accused or 7 other suspects. So as of now, we are actually looking at jurisdiction and legality of the court process, and then we're also looking at the process to ensure that this thing moves on, the court process moves on, because the prosecution team actually handed over a written document or written support to the presiding over judge, and also they have also handed over a copy to defense team, defending their ground on the fact that this court is competent to try the accused or the prime accused, Kang, among others. And with today, of course, you've seen how Freedom Hall is full to the brim. People from all walks of life converge there, and these elements, this shows the credibility. You could even see some seats. There is no space, no space at Freedom Hall. You could see if it was by your eyes. No space where you could sit. It is full, and I'm sure up to the outside. This indicates the matter at hand, that our people have been following this, and they have been waiting for this process to ensure it goes to an end. You could see that as our cameras are trying to relay to you this, it shows to the public or to the region and the international community that people of South Sudan, the ordinary citizen, have been actually waiting for this moment to ensure at least this case, it starts and it ends, and then it opened a new dawn or open a new chapter where people will now be able to see what next. As always, the saying goes, the suspect is always innocent until he's proven guilty by the court of law. And this is what is happening. And that's why you could see people from all of our walks of life. You've seen intellectuals, you've seen people like more national and international observers, you've seen scholars, you've seen family members, you've seen people who are not even related. You know, people of South Sudan, those who are having zeal, who are having this, hope just to go and listen how the process is going on. The process, this is showing the credibility that from day one, SSBC team have been saying that the process is credible, despite of the fact that there were some elements who are saying no, but you could see by your eyes that this process is credible, and people all the way from all walks of life converge to Freedom Hall to see how this process is going to ensure that fairness, openness, and impartiality actually take center stage. And to remind you once again, we're just awaiting the arrival of the 3 presiding over judges, headed by Dr. James Alaladeng, Justice Stephen Simon, and then Justice Isaac Pur Majak. These are the people that are seen by the country's judicial system to handle this case. And they are just, as soon as they arrive, they will pass verdict, and then we will proceed and see what next from here. The charges leveled against the accused, including, according to what is read by the Minister of Justice and Constitutional Affairs, Dr. Kang, he read it some times back. He read some of these charges, including accused on Treason Act. Then we have also murder, we have conspiracy, we have common intention, we have terrorism financing, we have financing of terrorist act, destruction of public property, military assets, crime against humanity, and then systematic attack on civilians and on ethnic-based persecution. So some of this case will be heard as soon as the court or the presiding over judge pass verdict on today's move. And let's go back again to my colleague, Matthew Joseph, Leila Osman, and Martin Justin Kose, who are doing great job at the courtroom. Let's hear what's happening as we continue relaying to you this live on Facebook, live, and we are also live on YouTube. Log into SSBC Official and also SSBC page. You will be able to watch us live on all the social media platforms. Let's go back to Freedom Hall, at Freedom Hall to hear what's happening at the courtroom.
مطلوق البطاي كلنا طالما دولة تانينا ماما دولة الدنيا كله مبتلى كلنا طالما دولة تانينا يا اخواني دولة العالم كله مبتلى ربنا ودي كله فوقه كيران البيسيبو بلد غانياني ربنا ودي كله فوقه كيران ماما كيران البيسيبو بلد غانياني كانينا قبل دولة دي مجل باكوين دولة دي بيكون دولة القوي كانينا قبل دولة دي مجل باكوين دولة دي بيكون دولة القوي جنوب بلدي أنا بهيبو مخلوق البطاي بلدي جنوب وطني أنا بهيبو مخلوق البطاي وطني جنوب بلدي أنا بهيبو مخلوق البطاي بلدي جنوب وطني أنا بهيبو مخلوق البطاي
كانت جهيبو بلد تاكي انت بيشتغل فوقه بكل قلبه وبأمانة
كانينا كربو دولة جميل دي ما كيراتو وما بيكون كويس كانينا كربو بلدي يافا دي ما كيراتو وما بيكون كويس ربنا بيحاسبو نينا يابواني كانينا ما في سو بلدي ربنا بيحاسبو نينا ماما كانينا ما ينو بلدي مسلياتا بلدي تانينا kulu sawa-sawa ina kutubala tanina mama sandola de berapa kwe junub beledi ana bihibu maklugel batai beledi junub watani ana bihibu maklugel batai watani junub beledi ana bihibu maklugel batai beledi junub watani أنا بيبو مطلوق البطاي dola de ketirle nina kagesi musawa sawa bitimu kerata bele de kifaya lenina kagesi musawa sawa bitimu mata geni zulu makwana dola de tanina sawa mata zulu makwana dola de tanina sawa geliba kebir de tasunude bekarabu dola tanina El batamade tasuno Bisibu bele abiraba Watani junub beledi Ana bilibu maklug el batai Beledi junub watani Ana bilibu maklug el batai Watani junub beledi Ana bihibu maklug el batai Beledi junub watani Ana bihibu maklug el batai
Lomizana en Vivid Studio Selector Isaka Phantom Best Production
Watani junub beledi Ana bihibu maklug el batai Beledi junub watani Ana bihibu maklug el batai Watani junub beledi Ana bihibu maklug el batai Beledi junub watani Ana bihibu maklug el batai Kelina talama dola tanina mama Dola al dunya kullu mubtene كلنا طالما دولة تانينا يا كواني دولة العالم كله مبتني ربنا ودي كله فوقه كيرات البيسيبو بلد غانياني ربنا ودي كله فوقه كيرات ماما كيرات البيسيبو بلد غانياني Kanina gobru dola de magel bakwet, dola de bikundo lalgowi. Kanina gobru dola de magel bakwet, dola de bikundo lalgowi. Junu beledi, ana bihibu maklugel batai. Beledi, junu watani, ana bihibu maklugel batai. Watani, junu beledi, ana bihibu maklugel batai. Beledi, junu watani, ana bihibu maklugel batai.
kanita gehibu bele take ita bishtaka fogo bekulu gelba obe amana
Kanina karabu dola jeni de makera kawama bikun kwens. Kanina karabu bele dia fa de makera kawama bikun kwens. Rabuna behasi bonena ya kwani kanina mafisu bele de. Rabuna behasi bonena mama kanina mainu bele de. Muslia tabele de tanina kulu sawa sawa. Na kutubala kanina mama sandola de tera bakwe. Junu beledi ana bihibu maklugel batai. Beledi junu watani ana bihibu maklugel batai. Watani junu beledi ana bihibu maklugel batai. Beledi junu watani ana bihibu maklugel batai.
Yes, viewers of SSBC, thank you so much for joining us. You're still watching live coverage on the court proceeding for Pout Kang and other accused. Live from Freedom Hall, you've just watched the panel of presiding over judges have arrived at the courtroom. And from here, viewers will be handing over the microphone to the presiding over judge, Dr. Justice James Alala Deng, who is actually supported by two other justices, including Justice Isaac Pur Majak and Justice Stephen Simon. Let's hear the final verdict as they preside or they take center stage of this case at hand. Back to Freedom Hall, where we hear from the presiding over judge as they have arrived. Stay tuned.
Morning to you. Let us start our session by giving the attendance to the court.
Honorable Court, my Lord, Denga Shura Dia, Consul General, Minister of Justice, the President of the investigator, the complainant, and the prosecution team in present. Thank you.
Good morning, Your Lordship.
Just wait. Yes.
Good morning, Your Lordship. Of Advocate Gary Raimondo Lege Lobate, the lead defense team, in the presence of my learned colleagues, Advocate Kurlwal Kur, Advocate,
present?
in the presence of Advocate Kurul Alkur, Advocate Anis Tombe, Advocate Deng John Deng, Advocate Warnyang Kir Warnyang, representing women in our side,
Thank you.
in the presence of the 8 accused person, 7, 8. Thank you.
Thank you. Session is for. I think the session is today is the decision on the 2 objections, the one of the defense and that of prosecution. Thank you.
Okay, good morning. Let's go direct to the decisions, and I'm going to read it out. On the 1st of September 2025, the President of the Supreme Court and the Chief Justice of the Judiciary of South Sudan constituted this special court to try criminal case number 1533 2025 for Nasser incident, March 2025, against accused person under sections 48, 50, 52, 61, 62, 65, 64, 65, 66, 67, 70, 71, 72, 75, 76, 206A and B, and 239 of the Penal Code Act 2008, and also sections 15A, B, and 16 of Anti-Money Laundering and Counter-Terrorism Act 2012, amended. On 22nd September 2025, the defense presented to the court an objection called preliminary objection. The title, Objections on Lack of Jurisdiction of the Special Court to try the first Vice President and the 7 others accused persons that may be summarized as follows. Number one, supremacy of revitalized agreement. And number two, jurisdictional and procedural objection. Number three, counter objection on the appearance of private advocates as part of the public prosecution attorney's team. As for the supremacy of the RI revitalized agreement, the defense cited Article 8.3 that says this revitalized agreement shall take precedence over national legislations and existing agreement to the contrary, and in the event that the provisions of national legislations or of previous agreement conflicts with the terms of the agreement, the provisions of this agreement shall prevail. And that the revitalized agreement 2018 provides under 5.3.1.1 for the establishment of hybrid court for South Sudan. This court is independent and established by African Union Commission to investigate and prosecute individuals bearing responsibility for violation of international law and applicable South Sudan laws. Committed from 15 December 2013 through the end of the transitional period. Nasser incident is a ceasefire violation, and therefore it falls within the jurisdiction of the hybrid court. Article 17 of the revitalized agreement 2018 that should be adhered to. Read together with Article 5.3.1.2 and 5.3.2.2. In addition to Article 201A, 7A, B, and D of the Transitional Constitution 2011 as amended. Furthermore, the defense mentioned that Article 9(3) of the Transitional Constitution of the Republic of South Sudan 2021 as amended provides that all rights and freedoms enshrined in international human rights treaties, conventions, and instruments ratified by or acceded to by the Republic of South Sudan shall be an integral part of this bill. So, trial of the accused persons disregard and alter-verse and unconstitutional. The defense also raised an issue of jurisdictional and procedural objection on the constitutional immunity of the first vice president, citing Article 103, 104, 2 of the Transitional Constitution of the Republic of South Sudan, 2011, as amended, read together with Rules 62 and 63 of the Transitional National Legislative Conduct of Business 2013 as amended 2021, that provides that the first vice president shall not be subjected to criminal proceedings while in office, except upon removal of immunity by 2/3 majority of all members of the National Legislative Assembly, and in accordance with the Rule 62 and 63, that provides that the provision of 62 shall, with the necessary modification, apply in respect of the first vice president and vice presidents. This raises questions as to when does court become competent. It is when it is properly constituted as regards yes, it is properly constituted. The subject matter is within the jurisdiction of the court, and case is put before the court based on due processes of law. This court is defect in its competency, since the President of the Supreme Court has no power to establish it before to establish it has no power to establish it before provisions of the Transitional Constitution 2011 as amended, Article 103, 104, 2, and provisions of the Transitional Legislative Assembly 2013 as amended 2021, Rule 62, 63 are adhered to, and also lack of resolutions that shall have been passed by the 2/3 majority of members of Transitional National Legislative Assembly as amended. The arrest and detention of the accused were carried out without due process of especially lifting of the immunity of the first vice president, and therefore the proceedings are unconstitutional, unlawful, and void. The accused person shall be immediately released, plus any other reliefs deemed fit by the court. The response of the prosecutions may be also summarized as follows. Number one, that provision of Revitalized Agreement 2018 and Transitional Constitution 2011 amendment number 6, 2020 limits jurisdiction of hybrid court to international law crimes and crimes under relevant South Sudan laws, including gender-based crimes and sexual violations, when and if established. There is no conflict between the revitalized agreement and national law in this case. The two are distinct. Number two, that it is only the president who is immune during his or her tenure of office, according to Article 103(1) of the Transitional Constitution 2011, Amendment number 6, 2020, and Rules 62 and 63 of the Transitional Legislation, Conduct of Business Regulations 2013, Amendment 2021. They deal with the removal if the Vice President and not trial, dealing with the removal of the Vice President and not trial of the same, since that does not override provision of the Constitution. Number three, that according to Article 123(e) of the Transitional Constitution 2011 as amended, the Judiciary Act 2008, Section 7F, and the Code of Criminal Procedure Act 2008, Section 16(4), give the President of the Supreme Court powers to constitute a special court to try any person accused under Chapter 5 and 6, inclusively, of the Penal Code Act 2008, and a written order for establishment of special court as required under Section 44 of the Code of Criminal Procedures Act 2008. Therefore, the special court has been duly constituted in accordance with the law, and it follows that the court is legitimate. Number four, that the Minister of Justice has power under Section 45 of the Ministry of Legal Affairs and Constitutional Development Organization Act 2008 to engage any advocate outside the ministry whenever necessary. Each party stood its position in its response and comment to pleading of another. And according to that point for discussion and determination may be summarized as follows. Number one, supremacy of the revitalized agreement 2018 as embodied into the Transitional Constitution 2011 Amendment number 6, 2020. Number two, President of the Supreme Court has no power to constitute a special court to try Nasser incident's crimes. Number 3, immunity concerning the first vice president who was not lifted when he was arrested. Number 4, a special court established by the President of Supreme Court is unconstitutional. Number 5, that private advocates who are on the side of or within the public prosecution have no legitimacy and should be sent away. And the 2 advocates within the defense teams lack or have no license and should be told to go outside the court or sit with the audience over there. Now, it is evident from the submissions that main points for the determinations are to be discussed as follows. Number 1, reading warrant of the establishment of this special court and argument of defense and prosecution, the court believes that there is no overlapping of jurisdiction between its competency and the one of hybrid court for its twice offenses committed in Nasser incidents in March 2025, and that hybrid court have jurisdiction within with respect to genocide, crime against humanity, war crimes, and other serious crimes under international law and relevant laws of the Republic of South Sudan, including gender-based crimes and sexual violence, as provided for in the Transitional Constitution of the Republic of South Sudan, 2011, Amendment number 6, 2020. The Constitution made it clear that the hybrid court shall be independent and distinct from the national judiciary in its operations and shall carry out its own investigations. The hybrid court shall have primacy over any national court of Republic of South Sudan, of course, when a conflict of law arise. So, the hybrid court has jurisdiction to investigate and prosecute in respects with individuals who violated applicable laws of South Sudan, which are relevant according to Article 5.3.1 and 3.214 of the Revitalized Agreement of 2018. It is obvious now that those applicable laws of South Sudan and its other relevant laws have not been identified or named in the Revitalized Agreement on the resolution of the conflict in the Republic of South Sudan in 2018. It follows that failure of the Revitalized Agreement itself to specify those applicable South Sudan laws and relevant laws of Republic of South Sudan made it difficult to understand the specific jurisdiction of the hybrid court itself in regards to the laws of the Republic of South Sudan, which fall within its jurisdiction, domestic laws. The hybrid court for South Sudan have not yet been established, and it is not clear when it will be established. National courts of South Sudan are operating and exercising their constitutional mandate according to the provisions of Article 122, sub-article 1 and 2 and 4 of the Transitional Constitution 2011 as amended, as long as they have not been suspended or withheld from doing their work by the hybrid court, which is in actual fact is not existing, since the national and hybrid court are independent according to the provisions of the Article 5.3.2.2 of the Revitalized Agreement 2018. Those special courts enjoys jurisdiction to try this case according to the Constitution 2011 as amended. Number 2, as for the jurisdiction and competency of the President of the Supreme Court to constitute a special court to try Nasser incidents, offenses, the law is clear that he or she has the power, bearing in mind the separation between hybrid court and national courts, as stated above. To explain, the President of Supreme Court of the Republic of South Sudan established Nasser Special Court according to provisions of Article 124, 122.4, 126.2, G3, and 127.1b of the Transitional Constitution 2011, in addition to the provisions of Section 16.4 and Section 44 of the Code of Criminal Procedure Act 2008 and Section 11.3.7f of the Judiciary Act 2008. Therefore, the court has jurisdiction and competence to try the accused persons, since the wordings in the Revitalized Agreement 2018 and Transitional Constitution 2011 Amendment number 6, 2020 says that the word that from 15th December through the end of the transitional period is not meant to hold back states' hands in addressing crimes, even if the hybrid court is active. The national courts have the jurisdiction and powers to prosecute offenses in the territory of the Republic of South Sudan. Therefore, it is the evidence that is the sticky yard to prove whether the subject matter of the trial belong to the hybrid court or national court. Number 3, concerning the lifting of immunity of the first vice president raised by the defense based on Article 103, 102 of the Transitional Constitution 2011 Amendment number 6, 2020, and Rule 62 and 63 of Transitional National Legislative Assembly Conduct of Business Regulations 20 Amendment 2021, which provides that the first vice president should not be subjected to criminal proceedings while in the office, except upon proper removal of the immunity by a resolution passed by 2/3 majority of all members of National Legislative Assembly. The prosecution replies to these claims in their submission. In pursuant of Article 106, 104, 103, and 102, the Constitution 2011 has amended, and provisions of 62, 63 of the National Assembly Code of Business, Article 103.1 confers constitutional immunity upon the President of the Republic of South Sudan only. And Article 104.2 of the Constitution is dealing with appointment and removal of the first vice president Provision did not expressly or directly mention immunity of the first vice president and other 4 vice presidents. As for the provisions of rules 62, 63 of conduct of business stated above, deals with impeachment of the President of the Republic, and Rule 63 of the same deals with the removal of the first Vice President and the 4 Vice Presidents. The 2 rules cited by the defense do not talk about constitutional immunity of the first Vice President, because the constitutional immunity is created or granted by the Constitution as the supreme law of the land in the hierarchy, according to provisions of Article 3.1 of the Transitional Constitution 2011 as amended, which reads, this Constitution derives its authority shall be the supreme law of the land. It shall be a binding force on persons, institutions, organs, and agencies of government throughout the country. Therefore, provisions of the National Assembly Code of Business 2013 as amended is a subsidiary legislation. It governs the conduct of business of the Assembly, which is subordinate to the Constitution 2011 as amended, and therefore it doesn't create or grant constitutional immunity to anybody in the country. On the contrary to the Constitution, for the above mentioned reasons, the first Vice President does not have constitutional immunity. According to the provisions of the transitional constitution. Therefore, the objection is rejected. Number 4, whether the special court established to try Nasser incidents is unconstitutional or constitutional. The Transitional Constitution 2011 Amendment number 6, 2020 says Judicial Services Commission shall undertake appropriate judicial reforms and restructuring of the judiciary during the transitional period. But the structure of the judiciary remains as it is under Article 123 of the Constitution above. Other courts and tribunals are part of the structure of the judiciary as provided for in Article A of the stated Constitution. Section 16 of the Code of Criminal Procedure Act 2008 provides for special courts, and it's specifically subsection 2 of the above provides that the President of the Supreme Court may convene a special court to be presided over by a High Court judge or any other senior judge, to be assisted by 2 accessories for the trial of tribal or sectional conflict and dispute involving capital offenses. Reading those provisions with the Judiciary Act 2008, you can say this is special court for Nasser incidents is constitutional and therefore has the competency to try the case as stated previously. Number 5, advocates here and there. Both parties to the case objected to certain advocates found within this or that team. prosecution and defense. Prosecution's objection is that Advocate Deng, John Deng, and Warnyang shall not be allowed to be within the defense team because they did not renew their license according to the law. Advocate Act 2013. Failure to renew the license at the end of January every year, the license shall be deemed to have been suspended. The defense is not denying that, but saying they were deliberately denied to do so by the Bar Association. Since advocates are tasked to defend legal and interests of their claims, to prevent injustice as guaranteed in the national and international instrument, the defense praised the court to reject prosecution objection, considering the period from January, from the end January up to now. It is a long time. The advocates in question would have tried possible means to renew their license, including going to the court to settle the matter. Appearing before courts without valid license violates Section 26 of the Advocate Act 2013. It follows that joining defense team without informing or even taking permission from the court may not be upheld, since it is a constitutional requirement under Section 136(2) of the Transitional Constitution 2011 as amended, among others. The advocates shall observe professional ethics. The only way now for them to rejoin the team is to remedy their position by using Section 102 of the Code of the Criminal Procedure 2008 and seek out sanction of the President of the Supreme Court to appear before this court. As for the private advocates with the prosecution team, defense objection has no merit, simply because it is obvious from Section 45 of the Ministry of Legal Affairs and Constitutional Development organization that the minister may engage, advocate, or make use of legal expertise from outside the ministry whenever necessary. This is his or her discretion powers. Therefore, the objection is refused and the decisions or the orders of the court are as follows. Number one, objections of defense teams are overruled. Advocates Deng John and Warnyang Kir Warnyang are ordered to leave defense team and seek sanction of the President of the Supreme Court to return back. Private advocates among within the prosecution team are allowed to continue. Thank you. Sit down, we finish. And after this, the disposal of these two objections, now we proceed to listen to the prosecution's number one witness, who is the investigator.
May it please this court, I would raise a procedural issue under section 224 of the Code of Criminal Procedure. And the procedure issue is that we are, as a prosecution, supposed to provide before this court our prosecution opening speech.
You are correct. Please proceed.
Thank you, my lord. Honorable Court,
we are still seeing the advocates who have been sent to go. Please let them go, and you are advised that you go to the Chief Justice and get his sanction and come back. We are very clear, all right? Thank you. Please go. Continue.
thank you, my lord. Honorable Court, this is the prosecution opening statement or speech. In this case of Republic of South Sudan versus Pout, Kang and others, criminal case number 1533 of 2025. Honorable Presiding Justice and distinguished members of the bench.
Don't be running. Just give us a chance to write. Yes. Opening speech.
This is a prosecution opening speech. We are going to give you copies of the same, and I will try to be as slow as possible as well, my lords. So this is the opening speech. Republic of South Sudan versus Pout, Kang and others. Criminal case number 1533 of 2025. Honorable Presiding Justice and distinguished members of the bench, with due respect and on behalf of the Republic of South Sudan, allow us to present this prosecution opening speech. On the 3rd through the 7th of March 2025, in Nasir County, Upper Nile State, the people of South Sudan and the world witnessed the gravest crimes that strike at the very heart of our constitutional order, endangered our national security, and traumatized and inflicted immeasurable suffering on the people of South Sudan. The government military garrison in which Yardiu, Nasir was attacked and overrun by the White Army militia. The government forces that surrendered on their own and those that surrendered on the persuasion of the fifth accused person, Dr. Riek Machar, including the late David Majur, who was to be evacuated by a UN helicopter. Those injured and those captured alive were rounded up and executed at point blank. The dead were dragged around and others dumped into the river and others left to rot where they were executed. My Lord Justices, on April 20th, the South Sudan People's Defense Forces, SSPDF, regained the control of Nasir Town and Yardiu military garrison. At Yardiu garrison, they were welcomed by the dry bones of their slain comrades, an apocalyptic scene comparable to the biblical phrase of Valley of Bones. But here, my lords, it was a barbed wire garrison, a plain land of bones overlooking the silent and grieving river. The prosecution stands before you today on behalf of the people of the Republic of South Sudan to seek justice for these heinous crimes committed by the accused persons. My lords, justices, this case is about individual criminal acts or omissions or responsibilities of the accused persons. I emphasize individual criminal acts or responsibility of the accused persons. The accused persons are namely Port Kang Chol, Lieutenant General Gabriel Droblam, Mampal Duor, Garawich Lampoch, Dr. Riek Machar, Brigadier General Camilo Gadmichael, First Lieutenant Mading Riek Yak, and Lance Corporal Dominic Gadgok Riek, who are present before you here, and others who are at large, namely Lieutenant General Peter Tokchuo Luak, Major General Dilling Care Chol Kuch, Major General Peter Ruach WBM, Lieutenant General Ye Dak Wiu, Major General William Dengbom, Kang Makana, Major General Kong Miang, Kwang Terjev, Garawich Liam, Biel Wiu, James Galwak Liu, Brigadier General Hogdor Chuol, and Pal Mai Deng. My Lord Justices, investigations were conducted of over 100 people, and the rest were released, and only these were the ones the prosecution has presented before this court to have been found culpable in the criminal acts that they are being charged with. In due course, Mr. Presiding Justice and distinguished members of the bench, the prosecution shall seek the indulgence of this honorable court to permit the prosecution of those absent and at large in absentia. The honorable Presiding Justice and distinguished members of the bench, the incident in Nasir in March 2025, characterized by brutal mass murder in cold blood, inhumane treatment, and total disrespect of the dead, and total disregard of the laws of South Sudan remains unforgettable and regrettable stain in the conscience of this republic. My Lord Justices, the prosecution will demonstrate that these were not spontaneous attacks, but actions of well-organized, well-financed, brutal criminal scheme. A criminal scheme carried out by the accused persons as they incited, organized, abated, financed, and weaponized a militant group, the so-called White Army, to target SSPD personnel, civilians, and undermine the government. My Lord Justices, the prosecution will avail evidence that the White Army did not act independently. They were under the direct command of the fourth accused person, General Gabriel Doplam, Major General Dealing Care, who is at large, and the fifth accused person, Dr. Riek Machar, and financed by the first accused person, Mr. Pout Kang and Mampal Duor, the third accused person. The attacks by the White Army were planned, funded, coordinated, and commanded by some of the commanders of SPLA-IO. We emphasize some of the commanders of SPLA-IO. The commanders in Juba coordinating the assault were Lieutenant General Gabriel Doplam and Major General Dealing Care. And on the ground in Nasir, the SPLA-IO officers commanding the White Army were namely the late Torgel Thon, Kang Makana, who is at large, Lieutenant General Peter Thokchuol, Brigadier General Manpinj Pal, Brigadier General Peter Palmut Yaj, Bol Doyak, and Major General Kong Moyang. This means the attacks were executed under the direct orders of the fifth accused person, who is the commander-in-chief of the SPLA forces. The evidence the prosecution will present will establish this clear and undeniable claim and the chain of command. It will demonstrate that the militant White Army operated under the direct command and influence and the strategic direction of the accused persons before you and those at large. My Lord Justices, there is a false narrative that this trial is a political witch hunt against the fifth accused person, Dr. Riek Machar, and the other accused persons. Contrary to this claim, my lords, this trial is about the rule of law. It is about giving justice to the victims. It is about having a closer to the victims, fighting impunity, and setting a new departure that crimes must be punished, that there must be a new chapter of accountability for all, regardless of status. Albeit this, it is inversely an opportunity for the accused persons as well to clear their names. In this commitment to the rule of law, my lords, the accused persons before you are presumed innocent as per our Constitution until found guilty by this competent court. It is to this commitment that this trial is open to the public. Further, my lords, it is to this commitment that the accused is duly represented by a competent defense team. And the Republic of South Sudan is willing and in position, given the nature of the offenses herein, to assign lawyers in addition, if need be, to defend the accused persons. The Honorable Justice and the distinguished members of the bench, the accused persons, Pout Kang and others, stand charged with treason, concealing treason, subverting the Constitution, insurgency, banditry, terrorism, terrorist financing, mass murder, destruction of protected property, treasury, attacks on United Nations personnel, unlawful seizure of a military garrison, and participation in an organized criminal act. These charges, my lords, are brought under the Penal Code Act 2008, the Anti-Money Laundering and Counter-Terrorist Financing Act 2012 as amended 2024, the National Security Service Act 2014 as amended in 2024, the SPLA Act 2009 as amended in 2020, and the Geneva Convention Act 2012. The prosecution will provide evidence proving beyond reasonable doubt that the accused persons committed the said crimes, and that the crimes are: 1, the crime of treason. Instead of paying allegiance to the Republic of South Sudan, the accused persons waged war against the state with intention to overthrow the constitutional government contrary to sections 64, 65, and 66 of the Penal Code Act. That the accused persons engaged in terrorist acts. The accused persons committed violence with the intention of causing forcible resistance to the government and to the defense forces and any lawful agencies, as well as possession and using dangerous weapons, contrary to sections 67, 70, 71 of the Penal Code Act. That the accused persons engaged in terrorist financing, the accused persons collected and provided funds with the knowledge that they would be used for terrorist purposes, contrary to section 14, 15, and 16 of the Anti-Money Laundering and Counter-Terrorist Financing Act 2012 as amended in 2024. That they committed mass murder. The accused persons abated the brutal and inhuman killings of armed SSPDF and wounded personnel, including the late Major General David Major Dak, the commander of SSPDF in Nasir, a UN personnel member, and 257 SSPDF personnel in Nasir, in violation of the Geneva Convention and the Penal Code Act, sections 10 and 206 respectively. That they committed as well destruction of protected property by damaging UN-marked helicopters, destruction of military equipment and civilian assets, contrary to section 67 of the Penal Code Act and the United Nations Convention on the Safety of United Nations and Associated Personnel 1994. And that they committed treachery by consciously giving confidential information to the SPLA-IO commanders on the ground and in Juba and withholding vital information from the SSPDF command, contrary to sections 64, 1, F, and G of the SPLA Act 2009 as amended in 2022. My lords, in terms of evidence, the evidence will point a picture of calculated violence that extended beyond military targets. It will detail gross violations of the Geneva Convention, including desecration of the dead and persecution of innocent civilians and UN workers. The prosecution will present a layered evidence strategy, beginning with testimonial evidence that will come from survivors, eyewitnesses, and protected witnesses who will recount the attacks, the planning meetings, and the consequences they endured. The prosecution will provide documentary and physical evidence like signed operational orders and autopsy reports. The prosecution, my lord, will provide digital forensic evidence like call records, WhatsApp communications, preserved and authenticated in compliance with international standards and international evidentiary standards. The prosecution as well will present expert testimonies from forensic pathologists, from digital forensic specialists, from military experts that will assist this honorable court in understanding the technical aspects of these crimes. This evidence will be presented chronologically, from the planning to the funding to execution to the aftermath, ensuring that each strand corroborates the other and eliminates reasonable doubt. My lords, the prosecution will meet this with the independent corroboration of witness statements, forensic and biometric evidence, authenticated through metadata, hash measures, hash values, and expert verification. In terms of procedural standards, my lords, the prosecution will assure the court that every exhibit is supported by an unbroken chain of custody. Vulnerable witnesses will be protected, including through in-camera testimony when necessary. In conclusion, my lords, this trial is a testament to our nation's unwavering commitment to the rule of law and to breaking this cycle of violence and impunity. The accused persons have been informed of their rights and their right to fair trial. We operate in a strict adherence to our constitutional standards and our obligations under international law. This trial, my lords, is about accountability, justice, and the rule of law. The evidence will prove that accused persons deliberately conspired to wage war against the state, terrorize civilians, and undermine the peace and security of South Sudan. At the conclusion of this case, my lords, notwithstanding the presumption of innocence of the accused persons before this honorable court, the prosecution shall respectively request conviction on all principal charges and the imposition of sentences proportionate to the gravity of these crimes, consistent with South Sudan laws and international standards. Allow me, my lords, to return the mic to you, if any, for the defense team to exercise their right of reply to our statement, and thereafter to the investigator who shall journey us through the process of demonstrating the evidence that shall be demonstrated before this honorable court to prove the charges against the accused persons. With this, my lords, justices, the prosecution remains appreciative of your patience. I end. Thank you.
Okay. Then the next step is that we go to hear the first witness.
Do they have the defense?
No, they don't have. The law is clear.
I think, Mona, you make announcement with the
Thank you, my lord.
Excuse. You know, it's very, very good. You know, while we're going to start, please, if there are witnesses of both parties within the audience in the court, are ordered to go out. If there are witnesses here in the court, let them go out. This is very important because if we discover that there was a witness inside the court listening to all these pleadings, we may not allow him to provide his statement. And also, let me take this opportunity to remind the media, those who are reporting, please stick to the rules of reporting, journalistic reporting. You should not go and start trying to pass your opinions or trying to analyze the facts that are given in the court. Please adhere to the law, to the provision of the law, domestically and internationally.
أنا داير نقول شنو؟ أي زول بيعتبر نفسه شاهد للدفاع أو للاتهام من فضلك قادر هذا المكان. نحن ما دايرين شهود في هذا الوقت. أي زول شاهد يطلع. شكرا.
Now let us begin with the first witness of the prosecution. There is no reply according to the law. that the defense... No, excuse, please, sit down. Let's start.
My Lord.
Excuse. Sit down until I give you...
My Lord, as you pass decision on the objections which were noticed by the two parties, we in the prosecution team in the position to request your honor that this session to be adjourned for tomorrow for verifications, all the exhibits and evidence which in our side to be presented by the investigator. Thank you.
Yes, the defense, what is your reply? Do you have any objection?
Thank you, my Lord. First and foremost, before I indulge to respond to our colleagues in the prosecution, I'm praying from Honorable Court to avail us with a copy of the decision read to us for some minutes. We need a copy.
The opening speech?
Yeah.
It's not given to you?
The ruling of this Honorable Special Court for our objection on point of law. We need a copy.
It's okay. You may be allowed to be given copy.
Thank you.
Whatever you want. But what is your response to the request for the adjournment for tomorrow?
Before I respond to the prayer of our colleague in the prosecution to adjourn this session, we are governed by Act Section 224 of the Code of Criminal Procedure Act, specifically 224 subsection 2, which allow us as defense of the opening speech. We are given also a legal right hearing the defense, evidence of defense to respond to what the prosecution have stated. We are ready. My Lord, Your Lordship, subject defense respond to the public prosecution opening speech. We act for and on behalf of the accused, His Excellency Dr. Riek Machar, the first Vice President of the Republic of South Sudan, Kang, Lieutenant General Gabriel Dub, Mampal Dor, Gadwich Lampoch, Brigadier General Camilo Gadmal Kel, Madingrial Yak, and Dominic Gatrok Riek, respectively. We submit this response to the opening speech delivered by our colleagues, the public prosecution, as follows. I want to bring the attention of our colleagues that in their opening speech, they just gave us a conclusion without giving us the facts. They have used command, influence, who command who, and who influence who.
Objection, my lord.
Yes.
My lords, based on the section cited, section 222, subsection 2B, that deals with the prosecution opening speech, there is nothing as a right of reply. If he's referencing subsection C, it talks of reply of the accused to the prosecution. That is a state that we have not reached to, because we are supposed to get into the statement of the inquirer, who is the complainant, and the statement of the complainant, if any, and the discussion of the same. What I was expecting is, my Lord, based on our procedure, this is a special court. When the investigations were completed, the investigator and the public prosecution took the evidence to the court. But given the sensitivity of the matter, the court then, before the establishment of this court, the Office of the Chief Justice advised that given the sensitivity of these evidences, it should be kept by the prosecution and only be availed before this honorable court on the start of the prosecution case. So what we are expecting, or what we are praying for this honorable court is, we sought an adjournment to allow the prosecution and the investigator to submit to this honorable court the evidence that is available. Because we cannot give it to the court, since the Chief Justice had advised that the special court had not been established, and therefore we must come and submit it to the special court. And we request for this, my lords, in the interest of justice and following our rules of procedure. Thank you.
Yes.
Your Lordship, it seems that the prosecution have forgotten about natural justice. And natural justice, the element of natural justice are two. One, odi altrum patrum, which means do not condemn somebody unheard. Second, nemo judice impropera posa, which means a monkey should not determine the affairs of the forest, which means rule against bias, which is part of Article 19 of our Constitution. The right to be heard is enshrined in the Universal Declaration of Human Rights, 1948. It's also enshrined in the International Covenant for Civil and Political Rights of 1966, read together, International Covenant for Social, Cultural.
Objection, Your Honor.
Please, let him continue.
Are you forgetting our rights?
Please, continue.
We have spoken, and this is my time to talk.
It's okay. Please shorten your response.
Thank you, my Lord.
Yes.
My colleagues, Your Lordship, the prosecution alleges that our clients and 8 accused are guilty of serious offenses under Chapter 4 and 5, Section 206, 239 of the Penal Code, read together with Section 15A, B, and Section 16 of the Money Laundering and Counterterrorism Act 2012 as amended, read together with all the sections mentioned in the charges. To succeed, the prosecution moved from must prove beyond reasonable doubt that the accused person committed each and every element of the alleged offenses unless and until the prosecution discharged that burden. The burden of proof lies on them to certification of this honorable special. The presumption of innocence must prevail. First and foremost, Your Lordship, and before we indulge into the fact and the law applicable, we would like to emphasize on the role of a prosecution attorney, because criminal law or penal court involve a contest between the state and accused person. It is imperative that both sides are represented by competent and ethical advocates or attorneys. The primary duty of lawyers for state prosecution and the accused or defense is to assist the court and the prosecutor and not to their respective clients as such. Thus, both sides have essentially similar obligations, although they come to their task from different perspectives. Your Lordship, a prosecution represents the state not the victim. His or her duty is not to secure conviction at all costs, but to ensure that all the evidence fairly and accurately adduced before the court of law. Your Lordship, a prosecutor is the Minister of Justice who represents the government in the public prosecution according to provision of Article 135, Clause 3 of the Transitional Constitution of the Republic of Pakistan, 2011, as amended. The prosecutor principal's role is to assist the court to arrive at the truth and to do justice between a community and the accused person according to law and the dictate of her. A prosecutor is not entitled to act as if representing private interest in litigation. A prosecution or a prosecutor represents a community of South Sudan, and not any individual and sexual entity. A prosecutor acts independent, yet in general public interest. The prosecutor interest is to be understood in that context as in historical continuum, acknowledging debts to previous generation and obligation to future generation. Your Lordship, in carrying out that function, it behoved him neither to indict nor on trial to speak for conviction except upon credible evidence of guilt, which credible evidence means believable evidence, reliable evidence, truthworthy evidence, evidence acquired according to law, not unconstitutional evidence or illegal obtained evidence, which will submit to this honorable court in due course. Let me repeat again. In carrying out that function, it behoved him, the prosecution, neither to indict nor on trial to speak for conviction except upon credible evidence of guilt, nor to do even a little wrong for sake of expediency, or to pick any person or please any power, not to be either gullible or suspicious, intolerant or overplanned, as we have realized from our colleagues there. In the firm and abiding mind to do right to all manner of people, to seek justice with care, understanding, and good confidence. They should not be biased to the government. They should be biased to the people of South Sudan. Restore justice in this nation, this beautiful nation of ours. Your Lordship,
My Lord.
it cannot be.
My Lord.
Thank you.
Yes. Let my learned colleague to stick on our opening speech, not to make reflection of what he is in mind, criticize the prosecution. This is not the time for him. Thank you.
It's okay, sit down. Please, please.
Your Lordship.
Doctor, try to summarize, because we have written...
Mine is only 5 papers, and we have done 2, remains 3.
Try to stick to their...
Your Lordship, it cannot be overemphasized that the purpose of criminal prosecution is not to obtain a conviction. It is to lay before a court credible evidence, relevant, related, connected, and linked with the facts. One of the ingredients of the elements of the crime, which all of us, we know in this room, actus rea, mens rea, and causa show. We need our colleagues there to stick to these 3 elements, ingredients of the crime: mens rea, actus rea, mens rea, and causa show, which means physical act, criminal guilt, and connection between the act and the deed and the result. Your Lordship, lawyer has a duty to see that all available legal proof of the fact is presented. It should be done firmly and pressed to its legitimate strength, but it must all be done fair. The role of the prosecution exclude any notion of winning or losing. His function is a matter of public duty than which in civil life there can be none charged with greater personal responsibility. It is to be efficiently performed with an ingrained sense of the dignity, the seriousness, and justice of judicial proceeding. Your Lordship, furthermore, Lord Macmillan, a Lord Advocate General in the Scotland and a member of the Judicial Committee of the House of Lords of England.
Please, Giri, why don't you just give us the paper and then we gain the time instead of...
I'm doing it. So this Lord says, we, in the discharge of his office, the advocate has a duty to his client who are here, a duty to his opponent who are there, a duty to the Honorable Court, a duty to himself, to myself, to ourselves, to respect this Honorable Noble Court, and a duty to the state, our country, the Republic of South Sudan. We are here for that. Your Lordship, the accused person prior to their arrest were subjected to politicized media campaign, outrages by ministers, politicians, and senior officers. In that campaign, explicit accusations were broadcast against them. The media broadcast against them to the public. This conduct amount to unlawful and prior conviction of our accused and a blatant violation of the constitutionality guarantee presumption of innocence, which is stipulated in Article 19, Clause 1 of our beautiful Constitution, read together with Section 6 of the Code of Criminal Procedure 2008, Laws of South Sudan. The accused is innocent until it is proved beyond reasonable doubt. And for our colleague, let me tell you from here, what is the meaning of beyond reasonable doubt?
Gary, please,
Let me conclude. Moreover,
you just try to conclude.
It is just only 3 lines. Moreover, the defense records...
Excuse me, Dr. Giri. You must know that Section 224 doesn't give you the right to respond. And we allow you to do that simply so that you enrich the procedures. Please try to summarize. Otherwise.
Thank you. I want to remind this Honorable Court that South Sudan belongs to common law and judges always make law in the absence of procedural fair. We have to do that to our country. Moreover, the defense records that the investigative authorities proceeded to arrest, interrogate unlawful search, and charge the accused person before their constitutional immunity had been duly lifted, and only thought to cure this defeat respectively. This violates the principle of legality, as a principle firmly recognized in our jurisprudence that what is built upon illegality remains invalid. It is null and void, ab initio, ad limine, from the beginning. Any such without due process of our Code of Criminal Procedure to our clients here are considered to be null and void, ab initio. Your Lordship, in addition, this case has placed the government in a position of embarrassment. It has been brought forward without proper official rights and without the request procedural foundation. This has left the public prosecution exposed to the extent that it risks withdrawal. This scenario mirrors a well-known precedent in which their late colleague, distinguished counsel, our late colleague, Charles Deng, our brilliant lawyer of this country, who passed on. He rejected to represent the government in the case of Asma Mahmoud, Mohamed Taha, and others versus government of Sudan in is published in the Sudan General Report 1986, where it was affirmed that the prosecution cannot sustain a prosecution in the absence of proper legal foundation. Honorable Justice of this Honorable Special Court, justice is neither proclaimed from political podiums nor declared in security offices. Justice is dispensed in the courtroom, beautiful courtroom like this, such as this special court under the rule of law. And the rule of law, our professor, Albert Van Dicey, has come with his book about that.
I give you 2 minutes to finish your speech.
Thank you. Your Lordship, a matter of fundamental importance arises in this proceeding, namely the manner in which the prosecution intends to establish that accused person is standing before this special court are responsible for alleged crime, of which crime scenes in Nasir, in the Upper Nile State. It is undisputed fact that the said location is situated at a distance approximately 712 kilometers from the city of Juba, where all these are here, and Nasir is far. How they manage, they fly up to there and come. We don't have transport from Juba to Nasir. We don't have a road. How they manage to go there, the burden of proof lies on he who alleges to prove the case beyond reasonable doubt. Your Lordship, the accused person have been detained since March 2025 up to 21 of September 2025 in a clear violation of their constitutional right. A person arrested by the police as part of investigation may be held in detention for a period not exceeding 24 hours, and if not released on bond, to be produced in court according to provision of Article 19 Clause 4 of our beautiful Constitution of the Republic of South Sudan. Number 2, every person shall have the right of a fair and speedy trial, and justice shall not be delayed pursuant to provision of Article 122, Clause 5, Paragraph B of the Constitution, our Constitution, read together with the provision of Section 6A of the Code of Criminal Procedure Act 2009. Number 3, every accused person is presumed innocent until his or her guilt is proved beyond reasonable doubt in accordance with the provision of Article 19(1) of the Transitional Constitution 2011 as amended, read together with the provision of Section 6B of the Code of Criminal Procedure. Number 4, no punishment shall be inflicted upon any person exceeding the prescribed by the law in force at the time such offense was committed. The prosecution operating in speech is fine with political rhetoric and general description lacking material evidence, real evidence, and the legal element of alleged crime. In conclusion, because to conclude I must, we will respectfully invite your Honorable Special Court to render the 8 accused person not guilty of any crime. Thank you.
Okay. It's good to when a written written أشكر فضل.
لقد تقدم الأستاذ مولانا دين تشيل ممثل الاتهام بتأجيل جلسة يوم غد الثلاثاء. إننا في الدفاع نعترض على الطلب الذي تقدم به ممثل الاتهام للآتي من أسباب: واحد، لقد ظل سيف الاتهام سلط على رقاب المتهمين منذ نهاية مارس 2025 إلى يومنا هذا، ولقد أخذ الاتهام في إجراء التحقيق والقبض والحجز لأكثر من 6 أشهر. إننا وفي اعتقادنا المتواضع لا نرى مبررا يستدعي تأجيل هذه الجلسة. علينا نلتمس المحكمة الموقرة رفض طلب الزميل والاستمرار وسماع المتحري.
Thank you, my lords. We all agree that this case has taken long, and in the interest of justice, it should move very fast. However, there are procedural requirements that we cannot jump, and that is providing this court our evidence. So we're requesting this adjournment not because we don't want to proceed. We want to proceed, but the requirement is that we must submit this evidence to court, so that it will be in the custody of court as we proceed with the court proceeding. It is our right as well to request for the same. So we insist on our prayer for adjournment so that we proceed tomorrow in the morning after submitted and verifying with the court police all the evidence that should be submitted to the court. It is not our own making, but it's because of the speciality of this court, the nature of this court, the uniqueness of this court. If this court was existing on its own before, we would have done this long before today. Thank you.
You see, it is for these reasons we allow even the defense to respond, while we are aware that Section 124 doesn't give the defense the right to respond. This is number one. Number two, we agree with the request because each and every party is supposed to give evidence in a thorough manner. Therefore, the session is going to be adjourned up to Wednesday after tomorrow. Thank you.
My Lord.
Go!
The judges have just left, and think what we are witnessing here is the court proceeding in this case is seen as a milestone in the history of South Sudan transitional justice and a taste of its might as witnessed in the courtroom and the argument between the two defense lawyers and the presentation from the prosecution against the charges pressed against the 8 accused. This is an open court. The public and the media are allowed to access the court according to the statement from the presiding judge, that is James Alaladeng. Today the prosecution team argued the charges against the 8 accused, and the judge also ordered the media in this high-profile case hearing. The media should stick to the rules of journalistic reporting in the court cases involving the 8 accused, that is led by Pout, Kang, and the public should be aware and should stay tuned to SSPC for more proceeding on the court cases. I'll hand over to my colleague Martin Joseph and Martin Kose for more details on the court proceeding for today. Martin, over to you.
Thank you, Leila Osman, for that update. As the presiding judges had adjourned the session to Wednesday for further hearing and presentation of the evidence and facts into the hearing of this high-profile case against Pout Kang and 7 others. If you have been following, you might have heard, the judges ordering the 2 advocates from the defense team to leave to exit the courtroom as they lack jurisdiction to be part of the courtroom as their licenses had expired. So one of the objections from the prosecution team raising to the court that the 2 advocates were lacking license for them to be part of the courtroom. So you have seen them being expelled, escorted out by the police out of the court, and were asked to go to the Chief Justice seeking sanctions from the Chief Justice, and then before they return to the court. This is from the judge. And also you have seen all the objections from the defense team were dismissed by the court, citing the constitution of the country being taller than anybody. And this court is separate from what the defense team were saying. This is all about the state and individuals having committed crimes against humanity and destroying public property. So it's not about targeting or removal or immunity of the vice president. It's all about individuals trying to destabilize the country. All the objections from the defense team were dismissed, and the court allowed the proceedings to continue, leading to the adjournment to Wednesday this week for further presentation of the evidence and facts from both parties. And this is how, reflecting the speciality of the court, of this court in handling this case, ensuring the country's justice, effective justice, rather. Now I would like to give the microphone to Martin Justin Kose to give you more updates in classic Arabic. And stay tuned to SSBC as we'll be giving you more details in our subsequent bulletin in the evening. Thank you.
Thank you, my colleague Mathiang Joseph. And actually today, as we have been following this court sessions, الجلسة الرابعة من المحكمة الخاصة بمحاكمة المتهمين في أحداث الناصر. وأول المتهمون كان بوت كانغ ومعه 7 آخرين بما فيهم النائب الأول لرئيس الجمهورية دكتور رياك الموقوف. ويعني جلسة اليوم حصل فيه تقدم شوية زي ما احنا كنا متابعين. أولا المحكمة أو قاضي المحكمة المسؤول فند أو كسر كل الاعتراضات اللي قدموا هيئة الدفاع، لأنه هيئة الدفاع كان قدم طعن في شرعية المحكمة وعدم قانونية المحكمة في محاكمة النائب الأول وغيره من المتهمين حتى في هذه القضايا. وأيضا أشار إلى أن المحكمة غير مؤهلة. المحكمة مفترض ما تحكم في هذه القضايا ما عدا محكمة الحجين المذكور في اتفاقية السلام المنشط. قرار اليوم المحكمة قال يعني انه كل هذه الأدلة يعني او كل هذه الاعتراضات لا أساس لها من الصحة، نسبة لعدد من القوانين الموجود في القوانين المحلية لجنوب السودان بما فيها الدستور الانتقالي القومي المعدل. وطبعا هذه الإعلان جاء استنادا كما ذكرت لعدد من القوانين أو عدد من البنود الموجود في الدستور الانتقالي وبما فيه حتى اتفاقية السلام الشامل، خاصة فيما يتعلق بمحكمة الحجين، دستورية المحكمة، وعدم يعني أو ما يسمى بالحصانة الموجود لدى النائب الأول. الدستور كان واضح جدا، الدستور لم يتعلق بحصانة لدى النائب الأول أو نواب رئيس الجمهورية، الحصانة فقط لدى الرئيس أو رئيس الجمهورية في خلال فترة حكمه أو حكمها إذا كانت أنثى، لا يجوز محاكمته في أي من المحاكم. المحكمة الخاصة كون بقرار من رئيس المحكمة أو من رئيس الهيئة القضائية، وطبعا الدستور ادعى الحق أنه يعين في هذه المحكمة. نعم المحكمة استمر، وبعد إعلان قاضي المحكمة هذا نتيجة اعتراضات هيئة الدفاع وهيئة الاتهام، نعم كل شيء الآن استمر القضية، لكن طلب الهيئة محامي الدفاع أو هيئة الدفاع بتأجيل هذه الجلسة ليوم غد لتقديم الأدلة، لأنه في خلال الفترة الماضية الأدلة لم يتم تقديمه. هيئة الاتهام طلب أن يقدم الأدلة لجلسة يوم غد، وبالفعل قاضي المحكمة أجل هذه الجلسة ليوم أربعاء القادم ليتم متابعة أو الوقوف على الأدلة التي سيقدمه هيئة الاتهام. إلى هنا أيها السادة والسيدات نعود بكم إلى الاستوديوهات الرئيسية في نيوكورن. إلى اللقاء.
Of the court proceedings of the accused, Kang, among others. And of course, if you could remember, when the court process or when the court proceedings started, just a bit of summary of what transpired during the courtroom. The presiding over judge, that is Dr. Justice Jamie Salala, read out the claims or read out all the written statement handed over by the defense team from the first day, second day, and third day, and also written response from the prosecution team on number of objections. One of the objections was on the jurisdictions of the court, and then also the legal process that they were saying the court is not legal to be able to try the accused, and then also moved on to claim that there are some private lawyers or private advocate who joined the prosecution team, as well as the defense team. Also, the prosecution team went ahead and also said there were some two advocates from the defense team who happened to have expired license. And according to the judge, by the demand of the Constitution, any lawyer who happened to have expired license is not supposed to have any legal mandate or legal ground to actually hear or to be in the courtroom. So therefore, the presiding over judge, that is Dr. Justice James Alala, actually nullified or rejected the claimed by the defense team on the jurisdictions, on the immunity, and also on the legal process of the court or special court set by the country's leadership or high court to ensure that this case of Nasir is being adhered or tried in the country. And of course, viewers, you remember very well that during the courtroom, there were a number of statements that were read out from the prosecution team. They have actually stood their ground and said they are ready to present all the evidences that is following the acceptance and passing of verdict by the judge that this court is competent now to hold on to continue to try the Nasir incident, and the prosecution team were allowed to give a statement where they actually aired out their ground, saying they are ready to defend the case and they are ready to move on to present forensic evidence, to present digital evidence, to present, or even bringing in the survivors of the Nasir incident to come to the court and attest or talked on behalf of what transpired during that event. So basically, the court process went on successfully, and there is much actually achievement which is being attained in today's prosecution. And you remember two of the defense team, that is Advocate Warnyang and Advocate Deng, were sent out of the courtroom by the presiding over judge to allow them to go and seek sanction from the president of the High Court to be able to get clearance on where or how to come back and join the defense team. On the other hand, the point raised by the defense team saying there are a number of private advocates who are attending the court on behalf of the prosecution team, the court actually said it is the legal ground of the defense or the prosecution team to be able to solicit, or the ministry has right to be able to solicit or get any private advocate to be able to stand in the process. So therefore, the advocates who are private were allowed to be part of the court session, and also they will continue with the prosecution panel or prosecution team. The next thing that happened is that the defense team also rejected a proposal made by the prosecution team to adjourn the court. But of course, the presiding over judge also said it is the legal right of the prosecution team to be able to call off the court so that they can be able to present in the next sitting, which is on Wednesday, present evidence on what exactly happened during the Nasir incident. Yeah. So the other thing is that viewers is the court adjourned to Wednesday. Basically, what next in the court, what is going to happen is that according to the presiding over judge, they will be now listening to the evidences that are going to be presented by the prosecution team. And of course, there are investigators who happen to be part of this team, and they will be presenting evidences on what transpired during the Nasir incident. As the prosecution team said, they have the evidences right from the planning, financing, execution of the incident. Therefore, it is upon that coming day, the Wednesday, that we'll be hearing this before the people of South Sudan. And of course, viewers, as it is always said, the accused is always innocent until he's proved guilty by the court of law. The process is still going on, and up to now, no verdict is being passed on anyone, but the process is following the legal procedure, or the court of law is following the legal procedure until the end of the matter, whether the accused will be presented innocent or they will be proved guilty by the court of law. Finally, viewers, we want to say thank you. It has been a pleasure having you and being with us from morning, and we are yet to meet again on Wednesday to hear the next move, as the prosecution team will be presenting evidences, as well as the defense team will have to also stand their ground to defend their accused, whether they are guilty or not guilty, and that determines where the court will move on. With this, I want to say thank you, and on behalf of the entire working crew in the studio and our team on the ground at the courtroom, we want to say thank you for joining us, and stay tuned to SSBC. We meet again on Wednesday on this special court case, and we hope justice will prevail at the end of the tunnel. Bye for now.